Parliament has passed the Supreme Court Review of Judgements and Orders Act 2023. The Act has also been signed and received the President's assent, and it is now the law. Now, what effectively does the law do? Section 2 of the Act says that in case a judgment or order is passed in exercise of the Supreme Court's original jurisdiction under Article 184 of the Constitution, the scope of a review shall be the same as an appeal. So it converts a review into an appeal, and although it's been said that it's just an enlargement of the review jurisdiction, it effectively gives appellate jurisdiction over decisions of the Supreme Court which have been passed under Article 184 of the Constitution. Now the question that arises is that can Parliament do this? And in this regard, it's important to point to the Supreme Court Practice and Procedure Bill, the operation of which was suspended by the Supreme Court. And in the Supreme Court Practice and Procedure Bill, it created an appellate jurisdiction over decisions of the Supreme Court which were passed under Article 184(3). And in suspending the operation of this law, the Supreme Court held that Item 55 of the Federal Legislative List only allows enlargement of the Supreme Court's jurisdiction to the extent that is expressly authorized by the Constitution. And the Constitution does not envision an appellate jurisdiction over Supreme Court decisions, it only contemplates a review jurisdiction. And although the government has tried to get around this by saying that it's simply enlarging the review jurisdiction and the scope of a review, if you look at the language of the new Act, it says that the scope of a review shall be the same as an appeal, and it's effectively converting a review into an appeal, and therefore in my view it's similar to the law which has been suspended by the Supreme Court. And another aspect of the law is that it applies retrospectively, and Section 5 of the Act says that it applies to cases which were decided prior to the commencement of the Act. Now, it's being suggested that this applies regardless of whether a review has been filed and decided, and in my view, it only applies where a review has not been filed and decided by the Supreme Court, and it's limited to cases where a review has not been decided. And it would not engage where the Supreme Court has already decided a review petition. And if the case were otherwise, you would expect the language of the law to say that notwithstanding the fact that a review has been filed, you get a second review. And because it doesn't say that, in my view, it doesn't contemplate a review of a review. And we've also seen a very public tussle between the government and the judiciary, and this first manifested itself in the government's failure to abide by the Supreme Court decision ordering elections on 14th May. And then we saw that various court orders were being passed giving bail to political leaders, and notwithstanding the fact that they were being given bail, they were being rearrested. And we've seen the government openly flout court decisions, and the precedent that is being set and the message that the government is giving is that if you don't like a court decision, or if a court decision is against you, you simply don't have to comply with it. And the implications of this are far-reaching. And we've also seen that Parliament has been passing legislation which relates to the jurisdiction and the procedure of the Supreme Court. And the Supreme Court has already suspended one such law. And it remains to be seen how the Supreme Court deals with the constitutionality of this new law, which effectively converts a review into an appeal. We've also seen that there's been a very public divide on the Supreme Court. Judges have disagreed over what constitutes a majority decision. The Supreme Court judges have, through their decisions, cast aspersions at one another, and the Chief Justice has been accused of running a one-man show. Now, it is clear that judges do not have to agree to everything when it comes to the law, and they can have different interpretations of the law, but what they must be united in is their duty to uphold and to protect the Constitution and fundamental rights contained in the Constitution. And for the sake of the credibility of the institution and for the sake of the future of the Supreme Court, it is hoped that the court speaks with one voice when it comes to protecting the fundamental rights, and it is hoped that this is done sooner rather than later.